number 133, matter of the New York Civil Liberties Union versus the New York City Police Department. Counsel?
Good afternoon. I'm Christopher Dunn with the New York Civil Liberties Union. With me is Robert Hodgson, also from the NYCLU. With the court's permission, I'd like to preserve 2 minutes for rebuttal.
2 minutes, sir?
Yes.
You may.
At the outset, I want to highlight this is a case about judges, not about cops. This is a case about the public's right to know about how the court, in the most influential police department in the country.
So, counsel, how do we reconcile those two statutes in favor of disclosure without FOIL swallowing up the court's piece in the civil rights law?
I think it's exactly what the Supreme Court did in this case and what every party before you agrees should be done, which is to redact the identifying information of the police officers.
Redact it? Is that what you said?
Yes. Mm-hmm. Yes. And so from the beginning, we have never sought identifying information about the police officers in these cases. Our request has been for the judicial decisions with all officer identifying information removed.
Well, what about the whole process set up in 50A, giving notice, giving a right to be heard? Are you saying that that process should be now incorporated into FOIL when something is sought that would be covered under 50A?
We are not saying that, Your Honor.
Okay, but then how does that not obliterate 50A and that whole process that the legislature set up?
Because I think that that process is set up to deal with a situation, which is the common situation, where the police officer's identity is going to be revealed through the disclosure of the personnel record. And in that case, 50A provides...
But sometimes that's not clear. I mean, in this very case, there seems to be an issue about whether redaction could sufficiently protect the officer's identification.
Well, with all due respect, Judge Stein, I don't think there is a serious question about that, but I understand what you're saying. And what I am suggesting is that the scheme that's set out in 50A, paragraphs 2, 3, and 4, deals with the situation where a record is going to be produced in an ongoing proceeding and the officer is going to be identified. Here, the whole premise of this FOIL is all the officer information comes out of the records. And it's our position that in that situation, which is very unusual, that those procedural safeguards just don't need to be addressed because all of that information is coming out. And therefore, there's no kind of process to be had with a judge saying, okay, is there enough of an interest to warrant
can't you just match the event to the officer? As I understand it, and I'm sure you know more about this than I do, but the disciplinary hearings themselves are open to the public, is that correct?
That's correct.
And so observers can go and watch and it certainly, while maybe not be able to identify all the participants, can identify the particular events. That seems to be clear, couldn't they?
Well, they could in theory.
All right, so if they could identify the particular events, then simply releasing the records, you can coordinate the event with the records and identify the officer.
Yeah, and to be clear, Judge Fahey, what we are saying is the sort of facts that would allow somebody to do that can be taken out of the decision.
Well, if you take those facts out, along with everything else, what's the point, I guess?
Well, there are lots of points. The facts that might identify an officer are not all the facts that are in an opinion, one. Secondly, let's be very clear. You and I do this all the time. We read decisions that have pages and pages and pages of legal analysis in it that say nothing about facts. These are judicial decisions. Some of these things are 50 pages long, as the city points out. There is a lot of law in there, and our primary interest here is in how judges in the NYPD are interpreting law that governs police officers. So, for instance, if judges in the NYPD think there's a Fourth Amendment exception to the probable cause requirement, I want to know about that. I cannot know about that now because these decisions, in their discussion of the law, as well as the facts, are entirely secret. So
I can see that. I think that's an interesting argument, a valid argument, but I'm still struggling with overcoming a number of hurdles before you get there, and I'm wondering if redaction is really the way you should be doing this, and if we actually have the authority to do that, particularly in light of 50A's requirement that there be consent by the officer. Some of the objections that were raised by the PBA in their amicus brief seem to be also compelling on the other side.
Well, let me address a couple things there, if I could.
Go ahead.
This court has never suggested, and no court has suggested, that redaction is only available if it renders impossible the ability to identify the redacted information. It's a common sense approach. We are talking about trials that took place 10, 12 years ago. Our request was from 2001 to 2011. The order that was issued by the Supreme Court Justice here was to redact factual details sufficient to conceal the identity of the officer.
But under FOIL, it's the agency that makes the determination as to what's sufficient and what's not. Under 50A, it's the court that makes that determination, and that's one of the things that troubles me here.
Fair enough, but Judge Stein, keep in mind here that we went through a court process in this case. The court
Yes,
ordered...
but you're not saying it's required in every case.
Well,
As a matter of fact, I think when I asked you the question, you said that the process set forth in 50A is not necessary.
I think that fairly read, and this court has never addressed the issue, but fairly read, when you were dealing with documents that are redacted of officer identifying information, that when those are sought under FOIL, that it is sufficient to have the agency make the redactions. On top of that, though, here, we did have a process, and this is unusual about this case, where the judge looked at 5 sample decisions that were directed to the city to produce with the redactions, and he determined that the redactions, in fact, were sufficient for purposes of concealing the identity of the officer. So here we have a situation where, while I don't think 50A required it, that we actually have judicial review of these documents.
Counsel, can I ask a question? I just want to clarify your position and your interpretation of FOIL. As I understand 87-2, it leaves to the agency complete discretion whether or not to invoke the exemption. So the reality is that the city could have chosen to turn it over anyway,
That's correct, Your Honor.
without any redactions.
You're absolutely
Doesn't
right.
matter what 50 says.
That FOIL allows
Correct.
production. That's
All right.
exactly
But they've decided to invoke the exemption, and so now this is where we are.
That's
But I just wanted to clarify if that was your interpretation
Yes. I
also
mean,
of the
that-
statute.
That's a little bit of an odd thing about the FOIL statute. It allows agencies to withhold documents. It doesn't require
Doesn't
them
that go to Judge Stein's point then as to what protection would 50A afford if all we look to was FOIL's permissive release provision? Then what civil rights protection is 50A or 50B for that matter giving to anyone? If an agency who has these records, how about the, documents that tend to identify victims of a sex offense? The agency could then make a decision, we don't even need to redact this, we'll give them to you.
Well, Your
And
Honor,
we're only applying FOIL.
happily, I'm not the agency. I'm not in that position. What we are dealing with here is a situation in which the agency did move to redact.
Right, but under your rule, the only issue is, putting aside 50A, the only issue is whether the agency is going to make a determination that they'll give them to you redacted, they may not redact them, and doesn't that gut the civil rights law?
Your Honor, I don't think it does. I think the agency has an obligation under 50A perhaps to redact, to respect the
So the officer
identification.
could bring a civil action against the NYPD?
Well, they can and they have. I mean, we have a dispute right now where the PBA has sued over the release of body cam footage, claiming that those are 50A protected records.
But 50A's coverage is not absolute even on its own terms.
That's exactly right, and that's an
So,
important
so
point.
if the legislature really wanted to make these documents absolutely confidential, no one can ever get to it, that's what they would have said. They didn't do that, and it does have a particular purpose. Could you address the question of the purpose and whether or not that's implicated at all in your FOIL request?
Well, I think it's definitely implicated in the sense you're absolutely right, that 50A does not create an absolute bar to production of personnel records. In fact, it creates a disclosure regime. And it allows for them to be disclosed if there's a process in place. And that's a situation, as I
But
said.
isn't that limited by a lawful court order in the context of litigation? In other words, it's not a FOIL request just to an agency, but instead 50A says These kind of records can only be released subject to a lawful court order, usually after in-camera review, and et cetera, and then in the context of pending litigation, not just through a request to an agency. This would subvert that process.
I don't think it subverts it at all, Judge Fahey. I think it
Okay,
complements it.
explain to me how it doesn't, because you're taking an individual's records, redacting them, and releasing them. So go ahead.
Well, I think I start with FOIL, which in its present form was enacted after 50A was enacted.
Right.
50A deals with this situation, as I said before, as I understand it, where the production of the record will result in the identification of the officer. Okay? And in that situation, 50A speaks to how to deal with that. In the FOIL context...
So let me stop you. So you have to, the record itself, you're saying, we both know the record can't guarantee that you won't be able to identify the officer, but in a common sense reading of it, if the agency determines that this record could not identify the officer, then it could be releasable if redacted.
Under FOIL, absolutely, without creating any 50A problem. And that's the whole premise of our position here, that we are looking for documents that can and have been shown to be redacted in a way that the officers are not going to be identified. We don't care about the officer identifications. What this is about is getting at the judicial decisions that the NYPD is issuing about police misconduct. And so what I'm saying to you in terms of the interest in FOIL and the interest in 50A, the redaction of the officer identification balances both of those interests, which is exactly what this court said.
But they argue that
Gallagher
but they argue to really have the kind of redaction that would ensure that one could never identify the officer, that would either be totally useless to you because everything's redacted, you get nothing from it, or it would indeed not be representative of the actual determination, which then goes to how it's helpful to you. Could you address
I'd
the
be happy
latter,
to.
not the former? I get where you are on the former.
Okay, well, so these documents, based on what I know about them, and I've seen examples of these, and you've been given examples of these, they have lots of information in there that is valuable to me and to the public about the way NYPD judges operate. And even if one were to take out all the facts, and I do not think that's necessary to anonymize them for police officer identity, there's plenty of information in there that is valuable. And the fact that it's incomplete, that's what redaction does in every single situation. And the city wants to describe that as distortion. It's just an incomplete document. And again, I just want to reiterate, there are all kinds of useful, valuable information. And again, going back in terms of the actual redaction itself, this court doesn't want to get into the business, I understand it, of going through documents and redacting. Judges do this all the time at the trial court level.
Thank you, Mr. Bloom.
All right. Thank you.
Counsel?
Your Honor.
I meant Mr. Dunn, excuse me.
I knew what you meant.
Good afternoon, Your Honors. My name is Aaron Bloom, and I represent the respondents to the New York City Police Department. Your Honors, this appeal presents the court with an opportunity to both harmonize three prior decisions that are in tension and provide guidance to a government agency and to government agencies generally trying to faithfully walk the line between two competing legislative
So let me ask you
policies.
also a question I asked your adversary. Is it the NYPD's position that 87-2 allows the agency to determine for itself whether or not it will invoke the exclusion, but it does not mandate the exclusion? Do you agree with that, or do you have a different reading?
I have a different view with
Okay.
respect to
Yes.
87-2A. So when there is another state or federal statute that mandates confidentiality,
Okay.
I don't believe that anything in FOIL authorizes the government to ignore that other law that mandates confidentiality.
Well, then
So-
what does may deny? Because that applies to all of the categories, including A.
That's correct, but I believe that nothing in may deny implies that another command that exists that says must keep confidential doesn't apply.
But then that doesn't make sense with respect to what A says, are specifically exempted, right? May deny what is already specifically exempted.
Well, I think that that's
Does that
just,
mean that this is the superseding statute?
well, I don't, Respectfully, Your Honor, I don't believe that's what that means. Otherwise, as I think Judge Garcia pointed out, many of the confidentiality statutes that exist would simply be discretionary. And I don't believe that has ever been the opinion of the courts that those statutes are discretionary. I believe that the may deny applies to all of the exemptions, and certainly where there are exemptions that are created by FOIL, those are ones that can be
What if the
asserted in
officer is
discretion.
deceased?
What
What if the officer is deceased? Does 50A, I'm not sure even I know the answer to that. Does 50A apply to those kinds of records where the officer is deceased?
I believe so, but
Okay.
I don't
So
believe we've...
that might be a case, right, where you could see that 2A would allow for the discretion.
I'm not sure, I'm not sure, but I don't think it pertains to this...
To this issue, fair
to this
enough.
case in particular.
Explain, as I understand your argument, however, you think that there's a distinction in 87-2A between between Civil Rights Law 50A and other statutes that fall within that exemption.
Yes.
How do we find a basis
Sure.
to judicially make such a distinction? Where in the statute do you find that?
I think you find it in A, the very structure of the statute, B, the legislative history, and C, this court's prior holdings, all of this court's prior holdings about 50A. All of this court's prior decisions say that the structure and the legislative purpose of 50A is very specific. It is about, and the touchstone is whether the records could potentially be used to embarrass an officer in litigation. That's the touchstone that's been constant throughout all of this court's decisions, and it comes from the structure of the statute, which is tailored to a litigation context, and from the legislative history. This statute is unique. Unlike many confidentiality statutes, it is about a specific use of documents. It comes from to prevent the use of records to embarrass an officer in litigation, also outside of litigation, but this court has always said the context is litigation, so to determine whether the records...
So then that helps to explain the process, right? Isn't your adversary then correct? The process that's set out in 50-A is focused on that very purpose.
Exactly, yes, Your Honor. And so what I would say about the process is that that process only pertains to the litigation context. And you know that from the text of the statute itself, because what the process says is after making a showing that warrants the records to be given to a court for in-camera review, the judge must decide whether those records are material and relevant to the action before that judge. So the standard set out in 50A really only makes sense when it's in a litigation context.
Let me ask this question. The position that you're taking before us today, is it different than the position that you took in the appellate division?
Yes.
Okay. How? In a one-sentence explanation, how is it different?
Well, we had we had two parts to our argument in the appellate division. One, that this court's holding in Short and Carlin controlled, and two, that effective redaction wasn't feasible.
Right.
Now, we argue that this court should harmonize Short and Carlin with Daily Gazette.
So, and basically you want us to do what you didn't want us to do in the appellate division.
Well, I wasn't before you in the appellate division, and I think that's the key
And
thing.
I wasn't there either, so we're clear on that.
But I mean, the point is that there was, from the perspective of a government agency, there was controlling Court of Appeals case law, Short and Carlin, which, at least on its face of the decision, appeared to control the decision.
I'm familiar with the cases, in the Daily Gazette case also.
Yes.
I understand the interplay between them. And it's a close question. I'm just wondering why the flip?
Well, again, because as a government agency, we're trying to do our best to comply with two competing legislative policies and the controlling case law. So when we're before an appellate division...
Can't you harmonize Short and Carlin with Daily Gazette by reading Daily Gazette as focusing on whether the documents themselves fall within what 50A describes as personnel records. So they're either exempt or they're not exempt, and if they're really not exempt documents, but there happen to be references within them to maybe some personnel issues, then it's appropriate to redact in those situations, but not if the documents themselves are the personnel records, again, that 50A is addressed to. You don't redact in those situations.
Your Honor.
Can't you read Daily Gazette that way?
Your Honor, I believe you can. And I'm not here to tell you that the only way to harmonize decision is the way that we're proposing. What I'm here to say is that we believe that there are two competing legislative policies here. There is a way to harmonize them that maximizes the open government principles that are embodied in FOIL, and that we believe that one can fully respect the legislative policy embodied in 50A if we harmonize the two decisions by allowing redacted disclosure, but only when effective redaction can be done that to a reasonable degree of certainty would preclude identifying
Why isn't
the
that
officer.
if you just look at FOIL and put aside 50A and the entire issue with whether 50A would ever allow this, but if we just read FOIL and Short and Carlin, you can do that. It's your call. I'm having some trouble understanding why you are asking us to overrule Short and Carlin, which in this case would allow you to do whatever you want. So in this case, if you think the records could not be properly redacted, you don't have to turn them over, and it's your call. In the next case, if you do believe that, you could turn them over. So I don't understand why you're asking us to overrule Short.
Well, I'm not sure how, in light, if Short is deemed applicable to if 50A falls under the rule of Short,
Right.
then Short says that redaction is not available.
Short says you can't force an agency to redact. Short, in fact, says the agency can redact.
Well, I guess
So no
that
one's
turns to
forcing
my
you then.
response to Judge Rivera's question, which is that we interpret the Short doctrine as saying the opinion in Short as not giving agencies free rein to do what they want, but that 50A controls, and unless redaction is specifically authorized, or unless this court says that FOIL, the use of redaction is authorized through FOIL to allow for disclosure, then we would not be able to do that.
Do you agree that the process set forth in 50A is not necessary or is irrelevant? In other words, notice, the right to be heard, and so forth?
Well-
And a decision made by a court as opposed to an agency.
I think that going forward, assuming if the court were to agree with our position that redacted disclosure, where effective, should be allowed, then in the normal course, either of a FOIL request or an agency that wishes to affirmatively disclose redacted documents, a lawsuit, some type of standalone lawsuit to seek judicial permission to do so would not be necessary and is not in keeping with how FOIL or general other principles work. That would be sort of creating a new sort of standalone cause of action. So we don't believe that that's the case. We believe that in this...
Do you agree with your adversary on that point?
Yes, on that point we do, although in this
I'm
case...
sorry, your position is you don't have to notify the officers and they don't get entitled to it?
Not if the agency has made a determination that that redaction is possible and sufficiently prevents the identification of the officers. And I just want to...
Do the officers get to weigh in on that decision?
Again, this is like many other instances under FOIL where potential disclosure of government records could impact third parties' privacy. And generally speaking, under FOIL, government agencies are entrusted to make appropriate redactions and disclose the documents without first having to go to a court.
So what would the implications of this policy be, say, for victims of sex offenses?
Well, again, we don't believe that this exemption applies to 50B. So, for instance,
Wouldn't the logic, though, apply?
No, and the reason is how I responded previously to a question, I'm sorry, I forget which of you asked, which is how do we explain why this particular statute should be carved out of the Shorten-Carlin rule. As we argue in the brief, Shorten-Carlin serves an important, the Shorten-Carlin rule serves an important purpose, which is to say that we don't presume that redaction would be authorized in all situations where the legislature hasn't made clear that it would be. But in short, there was an important footnote saying, we are unwilling to presume on the record before us that the legislature, that the only purpose of the legislature was to preserve confidentiality, and that purpose would be fully served by redaction. So we won't presume that. However, leaving open the possibility that in a unique situation, and I think we have that unique situation here, 50A, which is focused on a specific use of records to embarrass an officer, that purpose would be served if redaction can be done effectively.
So to clarify, is your position that redaction will depend on how the document is written?
The ability to effectively redact
I'm
it, yes,
sorry,
it could. Yes, it definitely could.
Yes, I'm sorry, I'm not being clear. Really what I want to know is your position is that redactions should be available, the court should try and harmonize these cases in the way you've suggested, but in this case, with these documents, redaction is not, I think you said, meaningfully effective.
Yes.
And so these documents should not be turned over, even in a redacted form. But does that mean that the class of these documents never get turned over? Or it depends on how it was written and I have to make that decision for each particular document?
I think it's a case-by-case determination based on the nature of the documents. I think we can look at this type of document here, but that's not to say that some other agency might call something by a similar name. I think each case you have to look at the type of document and how it is written.
So do you agree that it might be possible, just your adversary's hypothetical, that you could have one of these final decisions that's written in such a way that you redact all the facts, you redact all the names, all of that, and then you have pure legal analysis that does nothing more than, in his example, let him know whether or not a particular legal doctrine is being applied that he would argue is not applicable?
Well, I guess it's possible, but it is possible, I suppose, but the problem would be also whether by doing all that, one has effectively made that pure legal analysis acontextual and thus not really representative of, it's unclear how it was being applied in what way. So if the purpose is to assess whether the NYPD is properly applying legal principles, doing so when all the facts are deleted, I don't believe would be appropriate.
But that's not the standard for any other foilable document, right?
Well, I think that...
I mean, lots of, taking his point, documents get redacted regularly, and the person who gets it may say, this is telling me nothing, or this seems to tell me A, B, and C, and it's not what the government entity thinks the document really represents. I mean, isn't that the problem that's inherent, let me put it that way, in the redacting process, and there's nothing one can do about that?
It can be inherent in the redacting process, but I don't think that it's typically the case that you have a decision that has to be where so much of it has to be redacted, then you leave a sentence here or there, and then the question is whether enough of those sentences in enough of the decisions add up to something that could meaningfully contribute to the purpose of the request. I guess I want to address we didn't speak about some of the information that is available. As your honors may know, if the documents are made available, they would be available to the public. They could be posted on the website. The hearings are open to the public. Also, there have been there are civil lawsuits that often involve the same facts as these complaints. There are also news reports. There's also something called, the legal aid has compiled a database of information from civil lawsuits, from news reports, potentially from leaked documents, from other documents that have come out in trials that it has shared with all of the criminal defense bar with over 10,000 police officers in it. So there is in this case, I think, a substantial possibility that these types of records, even if the identifying details are taken out, they could be identified to particular officers. And once you start going beyond sort of discrete identifying details to the facts of the case, it's hard to say, take out this fact and not this fact without going the rest of the way.
Thank you, counsel.
Thank you, Your Honor.
Mr. Dunn?
Just a couple quick points. With respect to this notion about these are categorically not redactable, redaction is a document-by-document exercise. Judges do it all
That's
the
not
time.
what happened here, right? You sent 5 examples in, and the judge said, yeah, these look good, do the rest. So how can you say it's a document-by-document process?
Well, Your Honor, I'm saying, Judge Garcia, in terms of the general process, and I want to be clear that to the extent that the members of this court think that what needs to happen is a similar process for the balance of the documents, the court can do that.
Then would the police officer involved in that particular document have an opportunity to be heard as well?
Yes, just as they did here. But I want to be clear, that's a situation where the city agrees that's not necessary, but to the extent the court obviously thinks it is, that's a process that can take place. It took place for the 5 that we had here.
How many are the total universe? I forget.
Well, there's a dispute about that. We think, based upon the record, there are about 120 of these cases. The city believes that there are more. With respect to the issue about redactability, and Judge Stein, you asked about whether or not there's any basis for distinguishing within 87-2A between 50A and other statutes. I do want to be clear, we mentioned this before, 50A allows disclosure. The statutes, for instance, in short, which dealt with intimate personal information, namely abortion records of private individuals, did not allow for any disclosure. So short, which is not a 50A case, can be fairly understood to be a case that deals with private individuals with statutes that never allowed any disclosure, whereas 50A deals with police officers and policing, something at the heart of FOIL, and it allows disclosure under certain circumstances. And that is a basis right there for distinguishing between these types of records and the records that might be covered elsewhere by Section 87. Finally, in terms of this notion...
Let me ask you this. Let's say you have a case, let's say you wanted 10 years of documents, just make up a number. And in those 10 years, and we'll stay with police officers since that's the focus, obviously 58 covers more than just police officers, but we'll stick with the police officer. There's been one case of a police officer putting someone in a chokehold, the individual dies. Is it your position that they would be able to redact that? In a way that they could turn that over if that's the only case with that kind of fact pattern?
They can absolutely redact that, Your Honor. If that's going to identify Daniel Pantaleo as a member of the police department who was the subject of the disciplinary proceeding, of course they can redact it. The standard is you get to redact sufficient to conceal the identity of the officer.
But how is that going to be if there is only one individual that fits that category?
Well, they will redact the word chokehold in Staten Island in 2014 and Eric Garner. And it may be that, in other decisions, and let's say you were the one looking at it, you would say, with submissions from the officer perhaps, saying, okay, these are other things that have to come out.
But what if that was the only hearing in that period of time? And that hearing was a public hearing?
Well, that might be an instance, Your Honor, uniquely where they could withhold the entire document. That's okay.
Thank you, counsel.
All right. Thank you, Your Honors.
You're welcome.